Welcome, everyone. We're going to go ahead and get started. Welcome to our event. My name is John Fox. I'm president of Federalist Society. Welcome to police accountability and misconduct. When should police use force? Excited to have everyone here. I want to thank LAWSO as well for co-sponsoring this event with us. I'll go ahead and introduce the speakers. So we have with us today Professor Ryan Scott. He joined the IU Maurer faculty in 2009. He teaches and writes on criminal law and procedure, federal courts and jurisdiction, and the separation of powers. Professor Scott his research examines structural and procedural interactions between the judicial branch and other branches of government, particularly in the criminal context. He has written extensively on criminal sentencing in an area where legislatures and executive agencies have sought to constrain wide discretions historically enjoyed by judges. He also has studied efforts to influence judges indirectly through judicial appointment process strategies for encouraging judicial retirements and the semi-retirement program for senior judges. Before joining the Maurer faculty, Professor Scott clerked for Judge Michael McConnell on the United States Court of Appeals for the 10th Circuit. He then served as a Bristow Fellow in the Office of the Solicitor General of the United States. He also worked for 2 years as an associate in the Supreme Court in appellate practice at Mulvaney and Myers in Washington, D.C. We also have with us our keynote speaker, Alicia Hilton. She is a law professor in Shearman and Sterling and Chadbourne Park trained litigator and former FBI special agent. She received her Juris Doctorate and master's degrees from the University of Chicago, and she received her bachelor's degree from the University of California, Berkeley. Professor Hilton has been an invited guest speaker at more than 30 law schools, including the University of Pennsylvania, Duke, Vanderbilt, Boston University, University of Minnesota, Notre Dame, Arizona State University, and UC Davis. Previously, she was a visiting scholar at Chicago-Kent College of Law and a visiting professor at DePaul University College of Law and John Marshall Law School. She currently is an adjunct professor at Valparaiso University Law School and the John Marshall Law School. When she's not teaching, she works as an actor. In 2016, she had an acting role in the lyric opera of Chicago's production of Romeo and Juliet. She will return to lyric opera this year to perform an acting role in Don Quixote. Other upcoming acting roles include playing a Capulet in Joffrey Ballet production of Romeo and Juliet. Prior to practicing law and teaching law school, Hilton was an FBI special agent in New York. As an FBI special agent, she was a member of a foreign counterintelligence squad and also worked undercover in 2 long-term criminal cases, posing as a drug dealer with ties to organized crime. Professor Hilton's website is www.aliciahilton.com. So the format structure of this discussion, she will speak for around 25-30 minutes, followed by commentary by Professor Scott for about 20 minutes, and then we'll reserve some time at the end for Q&A. Just a reminder, our Federal Society's next event is Thursday, October 20th at noon. Do patent trolls pose a threat to innovation? And then also for those who want to continue this discussion on policing, accountability, and misconduct, I invite you to join Indiana Journal for Law and Social Equality that is having a similar event Friday, October 21st from 1 to 2:30. And without further ado, Alicia Hilton.
Thank you for inviting me to speak. I'm going to discuss misconduct briefly, give you an introduction as to what motivates some law enforcement officers to commit misconduct. I'll talk a little bit about the role of technology in law enforcement, how it's changed law enforcement today, and then I'm going to get to the very specifics with regards to the law surrounding misconduct and the use of force and some current use of force cases. So if you look at policing today, it's very different, for instance, than it was 100 years ago. Back when policing was first happening in this country, you had officers who were doing what we think of now as community policing. They were walking the beat. They knew the people in the community. And there was a lot of camaraderie sometimes in that situation. Now, people are spread out over a larger distance. We have a bigger population. And with the economy the way it still is, There's a situation where a lot of times when there used to be 2 officers in a car, sometimes because of budget, there's only 1 officer in a car. And because the officers are covering a large geographic area, there's not as much done on foot. There's more done in the car. Technology also plays a role with what we know about police and incidents. Obviously, most of you probably have cell phones, and there are also video cameras all over the country, whether they're at ATMs, banks, other businesses. So what you see on the news about police oftentimes is been provided either by citizens or it's from cameras in the area. Sometimes you also have dash cams on officers' cars, and you have body camera technology too. And I'm going to talk a little bit about how that has changed policing and the perception about police. Now I'll talk briefly about misconduct. Most people who go into law enforcement, and when I say police, I'm speaking very broadly. I don't just mean police officers. I'm also talking about FBI agents, CE agents, Secret Service agents, ATF, marshals, DEA, anybody who works in the law enforcement community. So most of these people who work in law enforcement, they go into the job with really positive motivations. They want to help protect people in the community. They want to aid victims. They want to stop crimes. They want to apprehend people who have victimized others and, put them through the justice system so they can't hurt people in the future. So that's what the motivation is for the vast majority of people in law enforcement. But just like in other professions, sometimes you get some people who are unethical. You get unethical lawyers, too, unethical doctors, architects, people in all professions. Sometimes those people who end up committing misconduct start out, as good police. They start out with positive motivations, and they end up going to misconduct either because of a situation on the job, perhaps they are overburdened with work, they feel like they're not understood by management, they are under a tremendous amount of job stress, they may have a supervisor who is unrealistic about expectations of the job, they may have a training officer who is corrupt or has a really bad attitude about the community. All of these things can contribute to changing an officer's mindset from thinking positive things about community and wanting to help people to having more of an us versus them mentality. There are also some people who go into policing with goals that aren't so altruistic. That those are the types of people who are immediately shaking down drug dealers for money, going after local businesses for protection money. Those misconduct cases are very clear-cut and very easy to understand. It's what you think about as noble cause corruption is hard to understand because oftentimes the officer has positive motivations in terms of the ends result. The officer wants to apprehend criminals. The officer wants to get drugs, weapons, other contraband off the street. But the means that the officer uses are not always within the law or within departmental regulations. With regards to use of force, there are some police and citizen encounters that are going to end up with force. That's the only way they can end up in a sense, because sometimes officers have to use force to protect other people in society. When you think about the standard for use of force, a lot of people do not understand what the law is, and the media has not helped this very much because a lot of the reports in the media perpetuate stereotypes or incorrect analysis of the law. I'm going to tell you about what the law really is. There's a case called Graham versus Connor, and it is a Section 1983 case. It's a civil suit. And that Supreme Court gives you the standard for what is supposed to happen in a use of force case. In other words, you look at what a reasonable officer would do at that situation, at that moment, with the exact same information that the officer or officers on the scene had. So it's an objective standard, and it's from the point of a reasonable officer. So when you think about what are the factors that you consider, the first is the type and severity of the crime. The second is whether there is immediate threat to the officer or others in the area. And when I say others, I'm not just talking about bystanders. I'm also talking about the suspect, the actual individual, that the officers encounter. In addition to that, you have to think about whether the individual is attempting to flee or is resisting arrest. And then the fourth category is a list of a bunch of different factors. Some of those are the condition of the officer and the condition of the suspect. That can be anything from whether the officer's been injured, the suspect's been injured, whether the suspect is under the influence of drugs or alcohol. And some people don't understand why that's relevant. Well, I'm going to tell you why it's relevant. When someone is under the influence of drugs, especially drugs like PCP, it changes your perception a lot. It is much harder for an officer or someone else to communicate with someone who's under the influence of drugs and to reason with this person because their perception has been clouded. Oftentimes they become paranoid and more aggressive. And another factor that's really pertinent is that sometimes these individuals who are under the influence of drugs, they also don't feel pain the way you would if you were clean and sober. So some of you may be thinking, why is that relevant? Well, when you think about the use of force, there's a lot of different levels with use of force. There is some controversy, incidentally, as to how you organize these levels. But the first level would be when the officer's encountering the individual and there's just verbal exchange. Someone's talking. Maybe you have some raised voices. The next level is when the officer has to put hands on the person, whether that's grabbing the person to try to subdue them and put some handcuffs off, proning them out, pushing them down on the ground. So that's empty hands. The officer doesn't have any weapon in the hands. The second level above that would be if the officer has to use either something like a baton or a chemical agent. And from there, there's some disagreement as to which one of these levels of force is more serious. But with regards to chemical agents, one of the things to think about is that some chemical agents are flammable. So if you use some types of capstone and other chemical agents, once you put that on the person, then you can't use a taser. Okay? So a taser is a type of electronic controlled device, and that obviously is a more serious, higher level of force. And then at the very end, you have the use of the officer's weapon, pistol, shotgun, a weapon. Now, in terms of the levels of force, there's a ton of misconceptions about levels of force. Some people think that the officer is obligated to use the same level of force as the suspect, or maybe one level of force above the suspect. That's not true. Remember, the subjective standard, the objective standard under Graham versus Connor is what a reasonable officer would do in that situation at that moment with the information that the officer has. One of the other things you have to think about in that sort of fourth category is whether the officer knows about the person having a violent criminal record or a history of mental illness, as well as possibly drug or alcohol use. So why is that relevant? Well, if the officer knows that this person has a history of violence or, even possibly some arrests or convictions for violent acts, the officer is much more likely to think, okay, this person is going to be aggressive and attack me or be much more of a danger to someone else versus an officer who doesn't have information. And with regards to mental illness, one thing that's a shame is that partially because of budget, partially because of, employment issues, a lot of departments haven't been able to train officers on how to interact with members of the public who do have mental illness. So ideally in a situation, if you have someone who's mentally ill, the officer on the scene will have had some training in that, because one of the new policies of some departments is to try to de-escalate situations. Some departments, instead of just sticking to the Graham versus Connor standards, they're actually asking their officers to be more careful about the use of force. And one of the things that is being stressed is de-escalation. In other words, trying to slow down the situation, and especially if someone is mentally ill, if they're only a threat to themselves and not a threat to someone else, you want to try to take some time, get some distance, get some cover, and try to diffuse the situation before any kind of force is used. So with these Graham versus Connor factors, you also, of course, have to consider, who the bystanders are. And whether you've got one suspect or multiple suspects, one officer, multiple officers, when I talked about the condition of the suspect, it's not just injuries, it's also how big this person is. So you think about all these different factors together. And with those situational factors and with the information the officer has about the suspect, whether that's from personal knowledge or something that the dispatcher has told the officer, that is how you calculate whether the officer has used a reasonable amount of force. So now let's talk about some current cases that have been in the news. One of the cases that I'm sure you've all heard about is the Eric Garner case. How many of you have seen the videos? There are 2 videos. Okay, this is a case in Staten Island, and Mr. Garner was accused of selling loose cigarettes, loosies. Now, when you think about police encounters, most of the time when police encounter someone, and it's been a use of force case that you hear about in the news, most of the time the situation started out because someone called 911 or they reported to the police a problem. So with the case of Mr. Garner, the police heard there was a problem. They heard that Mr. Garner was selling loose cigarettes. Some of you may realize that cigarettes are supposed to be sold by the pack. The U.S. government taxes cigarettes. They're not supposed to be sold individually. But in some neighborhoods where people are poor, it's more common that you will get people selling them individually because a person can't afford to buy a whole pack at a time. So this is an illegal act if he had done that. And it was during the day. A bunch of officers responded to the scene. They approached Mr. Garner. At first there was a verbal exchange where he basically stated he wasn't doing anything wrong. And the officers at that point had some choices because all they were doing was talking. They could have written him a ticket. They could have asked him to move on. They could have arrested him. The choice was made to arrest him. And one of the officers grabbed Mr. Garner, put a chokehold on him, and proned him out on the ground. So why is that problematic? Well, if you think about Graham versus Connor and you think about what type of force should be used, as far as I'm concerned, that was not a reasonable amount of force. The other big problem is the use of the chokehold. Not only is that against the New York Police Department policy at that time, they weren't supposed to be using chokeholds anymore, but I personally think it's dangerous, and a lot of people in law enforcement do think chokeholds are dangerous. When I went through the FBI Academy in 1991, we were taught an alternative maneuver. That's called the carotid hold. With the chokehold, you use this portion of your arm right here, and it goes up against the front of someone's throat. With the carotid hold, you use this inside of the elbow area. That's what goes up here. And so that is not pushing against the throat. It sort of cradles the throat. And then you use these sides of the arm and you press in against the side of the neck. What that does is it puts a little bit of pressure on the carotid artery, and then it makes the person dizzy. Most of the time, if someone starts to get dizzy, they comply. They stop resisting. You can get the handcuffs on them. You can arrest them. And what I was taught is if you use the carotid hold on someone, even though it's generally safe, I was taught that you have to bring the person to the hospital, get them checked out by a doctor just to make sure everything is okay. So with Mr. Garner, he did have some pre-existing medical condition. He was a big guy. He had some medical problems. The combination of the chokehold and being pressed down on the ground, he's a big person. He had trouble breathing, and he ended up dying. That case is also controversial because of the lack of communication between the police department and the community and the arguments over whether grand jury documents should be released. I'm in favor of transparency. When there is an incident between law enforcement and the community that involves force, I think that first of all, you shouldn't just have that local agency investigate it. You should have some outside investigator working on the case as well. There should also be openness between the law enforcement agency and the community. When you've looked at these other cases around the country, in some of the cases, when there's been an incident and the law enforcement agency communicates promptly with the community and expresses concern, discusses how the investigation is being handled, I don't mean you should turn over every information. Obviously, if something is a confidential detail that's important for the investigation, don't give out that information. But at least let the community know the investigation has been happened, that you have a fair procedure and that the community will understand, will be told what the outcome is, and the information will be shared with the public. When you have the open lines of communication, there's less likely to be people protesting, getting angry, feeling like there's basically the wool's being pulled over their eyes. You're less likely to have an us versus them mentality. The second thing is, after the fact, if something has gone wrong, that needs to be part of training. Okay? When you're in law enforcement, when you go through the police academy, the FBI academy, one thing that I learned is that at the academy I learned a lot about law. In some police academies, they learn about law, but they don't learn about criminal procedure. They don't learn about individuals' constitutional rights. I think it's very important for law enforcement officers to know about the 4th, 5th, 6th Amendment, to understand what people's constitutional rights are. Also to learn about law enforcement ethics. And when you think about procedures for conducting interrogations, arrests, etc., you don't want to focus on war stories that are just, like, we got the dope off the streets, we got the arrest. Talk about the procedures for getting things done in the right way. And if something has gone wrong with that law enforcement agency, use it as a teaching tool at the academy to tell the officers about how things should not be done so that you avoid tragedies in the future. Everybody in law enforcement, sometimes there's some incidents of misconduct. The FBI has a very open policy within the agency where FBI employees are given periodic emails that discuss what the acts of misconduct allegedly are, not the individual's name, but at least their job title, and then what the punishment is. When you have open communications with that within the agency too, then you have a perception of fairness, because you don't want people to feel like, okay, the officers in the beat are punished much more severely than the supervisors. Because you have an unequal treatment, then you're a lot more likely to have resentment. So I'll talk about one other case now that's in the news, and it relates directly to technology. Okay, the Key Scott case in North Carolina, you have a dash cam involved there, you have a body cam involved there, and then you have a bystander who happened to be the individual's wife with a cell phone camera. I talked about cameras. I happen to think that body cameras are a really good tool if they're used properly. When I say if they're used properly, that means they need to be turned on whenever the law enforcement officer is having an interaction with a member of the public. And you don't turn them off until the interaction is finished. What happened in the Scott case is that the tactical officer didn't have a body camera because in the department they don't have them. They're incidentally pretty expensive. They average around $800 to $1,300 a piece, and that's not the only cost. The cost of maintaining the data, the footage, sometimes doing the editing to improve the quality, that's more expensive than just buying those units. So you have a lot of cost there, but at least in that department in North Carolina, they'd issued a lot of body cameras to officers. So an officer on the scene had a body camera. That individual, unfortunately, forgot to turn it on or just didn't turn it on. The way those work, that particular model is manufactured by Taser, is that when it's turned on, it continuously is videotaping, but there's no audio. And every 30 seconds, it essentially overwrites. So that's why if you watch those videos on the news, the wife's video, there's audio because it's her cell phone. But then you have the dash cam that doesn't have audio, and then the officer's body camera, that doesn't have audio either until the very end. When he activates it, you have to punch the thing twice to activate it. And when you activate it, that means that you're actually turning it on so you got audio as well as video, and then it doesn't overwrite. It doesn't tape over itself. So then you have the footage. So when you do have cameras that are used properly, they do a couple things. One is they document the situation. So an officer is not falsely accused of misconduct, or if the officer is falsely accused of misconduct, that officer's name could be cleared pretty quickly if you have a good view and you're able to see everything, which obviously doesn't always happen. Another thing is that they can be a deterrent for the officer, because if the officer realizes the officer's on camera, the officer's less likely to commit misconduct than the member of the public. If they see that camera, sometimes they're less likely to commit misconduct. In some agencies where they've used the cameras, they found that the misconduct has gone down by like 50% or sometimes even more. And other agencies where the officers are not turning on the cameras, whenever they're encountering the public, the data is obviously not as good. So in the Scott case, there are a lot of factors that come into play, and the investigation is still ongoing, so we don't know how much information those officers had who were on the scene. After the fact, you have these reports in the news about how the individual did in fact own a gun, he did have a criminal record, it was a record for violent felony, he'd actually shot somebody in the past. So if the officers knew all this information, they would be much more likely to think he was a really serious threat. We don't know how much they knew. You have an officer who is repeatedly on tape heard, drop the gun, drop the gun, drop the gun. You can't see from those videos if there is a weapon or where it is. Later, you have photographs of the weapon. You have a marijuana cigarette as well. And you have a holster that Mr. Scott was wearing. So that investigation is continuing to be investigated. It's ongoing. Perhaps if the body camera had been on and we had audio from that one officer, we would know some more information, but you don't know that. There's no way to change that situation. But there have been a lot of other use of force incidents lately around the United States, and like I said, the community reaction is very different depending upon how the community sees the officers. So how do you improve relationships with the community? One is mentoring. Get officers out there to try to do more community policing, to get to know the community. Another is recruiting. Try to recruit people from the community so that the officers represent the community as a whole from a racial standpoint, cultural standpoint, etc. Sometimes that's kind of hard to do depending upon who's applying. But if you have officers interacting with the community and there's more of a positive outlook and image, you are more likely to get kids who are growing up wanting to become police officers. Then you do need better continuous training, not just at the academy, but after the officers on the street, to understand about constitutional rights, to understand about ethics, better stress management training for officers, better support for officers as well, because there is not enough of that. And the Department of Justice does have some initiatives that are helping some local police departments. One is they have a national academy at the FBI where they bring high-ranking officers in for training from all around the country. Another is that they do make videos that they will give to departments that are educational videos, not just about law, but about tactics. And then sometimes they also send FBI agents out to the law enforcement agencies. So these are some different ways that you can improve community relations and educate not just the public but officers on what the appropriate level of force is. Thank you very much.
The law and policy around police use of force is the number one issue in criminal justice in America today, and it raises such agonizing trade-offs. The government and individual interests are just the strongest imaginable, and that's what makes this discussion so wrenching. It's so hard to, it's a difficult problem how to regulate police use of force, and the current tools that we have are in many ways not up to the task. Let me start with the individual interests. We're talking about individuals' lives and safety. Black Lives Matter, the movement, is really about just stating forcefully that side of the balance and saying it has been underappreciated. Lives are being lost because of police uses of force. The Washington Post has put together an extraordinary database of police shootings that result in deaths in the United States. Last year there were 961 lives lost in police shootings. They have statistics on what was involved in each of them. The overwhelming majority involve people with weapons, people who are currently attacking someone else, but a lot of them don't. And at the margins, some of them are suspect. And we're finally getting at least somewhat better data on what's happening when police shoot and kill someone in the United States. But we're talking about lives and safety, the strongest possible interests on the individual side of the equation. On the other hand, police lives are at stake as well, and police safety, and the interest in law enforcement is powerful and legitimate. Policing is a very dangerous occupation. From time to time, when you read about this issue, people point out that policing is safer now than it's ever been. Far fewer police are killed in the line of duty today than, say, in the 1920s. That's true, but policing remains one of the deadliest professions in the country. The average civilian on-the-job fatality rate is about 3.4 per year per 100,000 individuals. The rate for police is 13.5. It's far, far more dangerous than other lines of work, like lawyers, for example. Far, far more dangerous than being a lawyer. As a reminder, don't go into logging. Incredibly dangerous. Logging and fishing, the most deadly professions in the United States. I don't recommend it. It's a very dangerous line of work, and police are encountering people at their worst, right? Police interact with the public in circumstances where we are on drugs or drunk or hurting someone and dangerous, and they see humanity in some of its worst moments, and that affects the way that inevitably affects the way that police officers carry out their work. They're alert to danger and sometimes too quick to pull the trigger because they face real threats and face them on a regular basis. So these are wrenching choices. The trade-offs are tremendous. The current situation is a crisis point. There is a deep gulf in trust between police and the communities that they serve, especially among black people. And it can't continue. It's a crisis point where, at this point, every police shooting engenders demonstrations and protests. And this represents, even in cases where evidence comes out later to suggest that the police acted properly, you get an enormous outcry of anger, and the police need to make changes to try to regain public support. I think there's a widespread agreement that more needs to be done to get public trust restored. So I want to make a couple of points today. One is about police misconduct and policies, and I want to talk about the proposals that have come from groups like Black Lives Matter, from the President's Task Force on 21st Century Policing from last year, proposals for reform and what is being proposed and how it might affect what police do. But I also want to talk about setting aside police misconduct, violations of the law, violations of departmental policy, conduct by police that conforms with all of those policies and nonetheless engenders distrust and suspicion, uses of force that comply with the law but nonetheless are making things worse, and what can be done to try to crack that kind of perfectly lawful but nonetheless counterproductive police conduct. Okay, so let me start with some proposals by Black Lives Matter groups and the task force. I should mention that Black Lives Matter, it's a loose group. It's not as if it's a one nonprofit or a group with a particular leader or agenda. So I'm going to talk about the Campaign Zero proposals, which I think are the most concrete and best fleshed out. And I'm struck looking at what the proposals call for by a mixture of both substantive changes to the law of the use of force, and here we're talking about the law of self-defense and the law of, I suppose, the constitutional law surrounding reasonable use of force under the Fourth Amendment, Graham versus Connor. And then in some departmental policies, which wouldn't have the status of law, but would nonetheless constrain police actions in other ways. So some of the proposals include requirements that deadly force should be used only in cases involving an immediate threat to an officer's life or the life of another person, where such force is strictly unavoidable to protect life. That's an important substantive change because it would eliminate serious bodily injury as a basis for using deadly force. Only if life was at risk would deadly force be authorized. And some other proposals that Campaign Zero has advanced include evaluating the reasonableness of an officer's conduct in light of their technical conduct and decisions leading up to using deadly force. In other words, it's one thing to say at the moment that the trigger was pulled, there was a threat of deadly violence, for example. Someone's life was at risk. But perhaps the officer made mistakes in the decisions that led up to that conflict. It was this unavoidable conflict. Think de-escalation. And it reminds me of, first of all, these are standards that would apply not just to police. These would be standards for the use of force in self-defense cases as well, which means that citizens or neighborhood watch folks like George Zimmerman would be subject to the same rules. And it strikes me that in the George Zimmerman, Trayvon Martin case, that was really the nub of a lot of people's concern about the use of force. It wasn't necessarily what happened at the moment that he pulled the trigger at a time when there were witnesses saying that the victim was pounding his head into the ground. Maybe there was a threat of deadly violence there. The concern was about the fact that he provoked the conflict in the first place through racial profiling, through confrontational behavior. This was an avoidable incident, and so this action leading up to it should be taken into account. In addition, Campaign Zero proposes that there must be a verbal warning every time deadly force is used and a reasonable amount of time to comply with that warning. And without giving a verbal warning, the use of deadly force is always unjustified. And then some other rules, things like no shooting at moving vehicles, no standing or moving in front of a moving vehicle, no chasing vehicles at high speed for anything other than a violent felony. All of these, it strikes me, so features of the proposal that I think are striking, a lot of them are Brightline Rules in an area that has historically been governed by flexible standards, and there's a reason for that. I think the sense among the activists who are working in this area is that the flexible standard of cases like Graham versus Connor ends up licensing police behavior in almost all circumstances. When it's a totality of the circumstances, the threat as one that can almost always be, at least a jury will find that there's a good reason to have used deadly force. And so this is an effort to try to put some rules in place, give warnings, don't ever do fire at vehicles, for example. More Brightline Rules, fewer exceptions, narrower justifications for deadly force. In one sense, I find this appealing because it's not officer-specific rules. These are rules that would apply to everyone. On the other hand, I have a hard time imagining jurisdictions adopting rules like this precisely because they take this bright line form. I can't imagine a jurisdiction actually adopting the rule that it's always unjustified to use deadly force without giving a verbal warning. If someone is actively stabbing a victim, you don't have to take time to say, stop that first, right? You've got to fire right away. Please stop the stabbing. When you take bright line rules, they always malfunction in individual circumstances. So I'm not convinced that all of these changes are workable. But I think it's striking that they're trying to give some more fine and detailed instructions to police because of a sense that a more flexible totality of the circumstances approach isn't working. On the other hand, departmental policies likewise would have some more specific guidelines, including the Campaign Zero folks would ban not just chokeholds, but all strangleholds, including carotid restraints, hog tying. They would encourage less than lethal methods, things like tasers. But the idea is to put in place policies that would encourage de-escalation. We've got laws on the books, it's both the law of self-defense and the constitutional law of the use of force, and we've got departmental policies. The Garner case is a good example of a department that adopted a policy saying never do this, and police did it anyway. Why is this happening? Why is there so much concern about use of force, given that we have prohibitions against unreasonable uses of force already on the books? You've alluded to a few of the reasons, but let me just tick through a few of them. For one thing, other than the constitutional standard of Graham versus Connor, which is a Fourth Amendment standard binding on everyone, these are rules that have to be adopted at the state level or by individual police departments. These aren't, by and large, constitutional rules. They need to be voluntarily adopted in particular jurisdictions, and there are political restraints on the adoption of those rules. And even if there is a rule on the books, a self-defense standard, like a reasonable belief that there's an imminent threat of death or serious bodily injury, or the constitutional standard, there are barriers to enforcement of those rules. Let's start with the practical barrier of getting evidence that's sufficient to make clear that there was an unreasonable use of force. Body cameras are a fairly recent development, and I like Ms. Hilton, I am bullish on body cameras. I think that used correctly, they can do a lot of good. There are some concerns about individual privacy when police are videotaping interactions, but I think those are manageable, and the upside is significant. The cases where you have seen discipline of officers officers, prosecution of officers, almost all had to do with indisputable video evidence that gets public in some way. I don't think that's any accident. Because without it, it's often a he said kind of dispute, or worse, the police are the only ones who survived the incident, and their story is the only one that gets told. That makes it hard. I don't mean to suggest that police engage in pervasive lying about this sort of thing. I have no doubt that these are real threats in the great majority of cases. But it's impossible to tell. So building a case is often difficult because of evidentiary challenges. Criminal prosecutions of police officers are exceedingly rare either for murder, as in a case where someone just is unjustified in using force, or for civil rights violations. The federal civil rights statute, the criminal statute, requires a willful violation of someone's civil rights, which is a very hard mental state to prove. And the constitutional standard, as we've said, has very few bright lines. It's hard to get juries to convict for crimes like this. Juries tend to be sympathetic to police officers, and I've seen that in a couple of high-profile cases that didn't even get past the grand jury stage, right? No decision, even that there was probable cause as to a criminal charge. Civil suits, also very rare against officers for illegal use of force, so excessive force. That's partly, again, the constitutional standard. In addition, qualified immunity protects officers from individual damages for all but the most extreme knowing violations, reckless violations. Indemnity rules at the local level may also shield officers from individual liability. Violations of department policy could be met with administrative sanctions, but that's a kind of self-policing by officers, and it depends again on the commitment of departments to enforce those rules. Early intervention systems are a promising way of trying to identify officers with a track record that looks like it's going to cause problems, but it depends on departments being willing to follow through on them. And even some departments that have developed early intervention systems don't always use them to full effect. And of course, disciplining an officer does nothing for the victims of an illegal use of force, right? This is at most an after-the-fact, it's a reactive kind of response as opposed to a proactive one in too many circumstances. Let me mention a couple of, I talked about the second kind of concern. It has to do with conduct that's perfectly lawful, but nonetheless is a use of force that is avoidable and maybe inadvisable. And I think officer training historically has really focused on the substantive law. It's focused on what the Constitution prohibits. And think about officers in the search and seizure context, right? The law of search and seizure is almost entirely constitutional law. It's rules about when you can conduct a search, when you can do a search incident to arrest, can you conduct a search of the car, can you impound it. All of these are constitutional rules. And so officers learn the constitutional rules so that they can do everything that is allowed under the Constitution, right? The idea is, I want to solve crime, and so whatever the Constitution permits, I ought to do. That's the lesson that I think has traditionally been conveyed in officer training. On the other hand, that might be exactly the wrong kind of message in the use of force context. It's one thing to say that the Constitution permits a use of force in this circumstance, and another to say that it is a good idea. And I think that a lot of the distrust that has emerged between police officers and the communities they serve has to do not with violations of policy, but with actions that could have been avoided. In other words, perfectly lawful but inadvisable police actions. And on that front, I wanted to highlight a proposal that the President's task force made in connection with compliant actions by police that comply with policy, but nonetheless raise concern for a variety of reasons. And these are Sentinel event reviews, they're called, near-miss reviews. These are reviews internal to a department after an event happens that didn't violate any policy, that was lawful, but where the department thinks that this was perhaps a misjudgment, that this was something that was avoidable. And it's comparable to peer review systems in medicine and aviation. Doctors, for example, will have these kind of near-miss reviews when, thank God, the person survived, or this could have been worse. But we think we could have done better. Well, how could we have improved? And there are strong protections, confidentiality protections. Use immunity is given to people who testify in connection with these reviews. The idea is to have a totally candid discussion of what went wrong and with the idea toward improving conduct, even if it was compliant with policy. I think that sounds like a promising addition to the arsenal of tools that police departments should be using to evaluate officers' action, one that might help to get at actions that are compliant with policy. Because in the end, I'm skeptical that changing these rules, even in some of the quite aggressive ways that the proposals from the Campaign Zero would do, will make much of a difference given the many limits on the effective enforcement of those rules, even if they're on the books. I think in the end it's a culture change that needs to happen, and so at least that has to be part of the strategy to go beyond changing policies. I'll stop there and we'll take your questions.
We have a few mics that will be going around for people who have questions.
Testing. Oh, mine's on.
Oh, hi. I wondered if both of you could address the militarization of police. I think the current training is to respond aggressively and affirmatively to any situation. This wasn't the case years ago when you had Officer Friendly who knew everybody. And in England, I heard about I've been reading about them having a de-escalation plan, so they de-escalate, whereas here we tend to escalate. If you don't obey a command in a half second, you're on the ground and you got a foot in your back. Like there's an example of a woman smoking a cigarette in the car. He said, put it out. She said, well, it's my car. And then boom, you're on the ground and you're in a chokehold. So I wonder if you could address the fact that there's a much more aggressive training in the United States than in Europe, at least in England. Other countries, I don't know.
As someone who's gone through law enforcement training, you can speak to this one.
I'd be happy to talk about that. One issue that's with regards to de-escalation is that several hundred police chiefs just met this past January to talk about policies surrounding use of force and training. And de-escalation is a policy that a lot of these police chiefs are stressing, and they're teaching within their departments now. They've gotten rid of, in these departments, they've gotten rid of, for instance, the 21-foot rule, which was an old policy where the belief that if someone had a knife or some other weapon, once you got within 21 feet, you could use deadly force against the individual. So a lot of departments have abolished the 21-foot rule. A lot of departments are trying to give better training to officers on how to interact with people in the community, for instance, who have mental illness. They're trying to equip the agencies better with riot shields. Now, you may think, oh, that's militarization. Well, it's a good way to protect yourself when you're a police officer if someone has a bat or if has a knife. And so you can raise that up to protect yourself and not necessarily have to shoot the individual. So sometimes the equipment that these departments get, these police agencies get, is an aid to de-escalation and assisting the officers to not use deadly force. When you compare England to the United States, my son happens to live in England. I'm familiar with that country, and that country is very different than our country in terms of the weapons that individuals own on a day-to-day basis, the gang violence that we have here, some of the other problems, the population, how in some areas it's very dense compared to some areas in England. So it's not really fair to compare an apple to an orange per se. But I would say that if you're interested in changes in policy that are happening for the better, look at those several hundred different police chiefs who are around the country who are going beyond the Graham versus Connors standard, who are increasing the stress management support, who are in favor of the body cameras, who want officers to, if it's possible, to hang back and wait and take cover instead of acting immediately. As I said before, it is not always possible. And some of these new Brightline Rules you suggested obviously don't work. The one, for instance, requiring a verbal warning is not a workable rule, not just because someone might be getting stabbed, but because you have things like hostage situations. One of the rules you mentioned with regards to shooting at a moving vehicle, that's one thing that that those police chiefs said, is a lot of departments now have a rule saying you are not allowed to shoot at a moving vehicle if in that moving vehicle the only weapon is the car. okay? So if someone has, for instance, an assault rifle and a car and they're strafing people as they drive down the street, well, then you want to take out that driver so they don't kill a bunch of bystanders. But if they just have the car and that is what they are driving, you are not supposed to shoot at the car. So there is an evolution in the way police now are responding and training, and it's not just the community that's concerned, it's the individual management, and officers. They're trying to make situations better and to have use of force decisions that are made in a safe manner for the officers and for the general public. Other questions? Yes.
In the most recent presidential debate, we had one candidate talk about re-implementing stop and frisk. Stop and frisk and other quota policies have a history of a lot of racial profiling and abuse. And of course, if you as a person are more likely to be involved with the police, you're more likely to be involved in a certain in tragic instances like this. Can you talk about racial profiling and, in a general sense, I guess? Thank you.
Yeah, so you're right that it's indirectly related to use of force because every interaction can blossom into a use of force situation, and if police departments systematically target people based on race, that increases the odds that you'll have a use of force incident. So stop and frisk was, I loved the discussion in the debate because Donald Trump is trying to say, there was a court decision that held that the New York Police Department's implementation of stop and frisk was unconstitutional because it systematically overrepresented African Americans. That decision was on appeal at the time that de Blasio was elected, and they decided not to pursue the appeal anymore. So it never really, it kind of wasn't quite decided. He's blathering about, he just poorly described what has happened. Essentially, I think that was going to get overturned on appeal, was what he was saying. But then we never got to see, got a chance because the new administration was going to end the policy anyway, and they mooted it and dropped the appeal. He might be right that it was going to get overturned on appeal. That at least some aspects of the jurisdictional basis were questionable in that case. But stop and frisk is controversial precisely because it is seen as and stopping and frisking is perfectly legitimate if you've got reasonable suspicion to believe that the person is armed and presently dangerous. The way it was used in New York City was as a way of enforcing against for routinely stopping people and frisking them for minor violations, and it was seen as part of this broken window strategy: deal with small issues before they become big issues. But the effect was a striking racial disparity in the population that was subject to it. The constitutional law in this area is a little less settled, I think, than the debate made it seem, but nonetheless at least adjacent to questions about police use of force.
You had brought up a conversation about the budget and its hampering of everything from partnerships and how much ground is being covered. My question would be, what is your opinion on, or where's the pendulum swinging, and is that just a need for more funds or a reprioritization away from certain equipment or towards other equipment, or where is training versus equipment versus more personnel factoring into budget decisions?
I think that good training is vital, that you want to also obviously have good screening and make sure you hire people who are ethical and who will hopefully have good relationships with the community. Putting some money into recruiting to try to get a diverse pool that represents the community, that's a good use of resources. Having really good training, not just at the academy and afterwards, excellent use of resources. Having officers in an adequate number out in the street to do community policing, extremely important. You also have problems with some police departments having cars that are constantly breaking down. I mean, you can't have an officer who has a car that's literally doesn't drive. And it is problematic in some communities where you only have one person per car. That's pretty darn dangerous, especially, if you're an officer, especially going into certain communities. So as far as that goes, Chicago is an interesting example. I live in that area right now, and the mayor is now talking about hiring quite a few new police officers and getting new cars. This happened after violence touched his family. Rather interesting how sometimes when things get personal, all of a sudden you see the light and you realize that there is a need for change. But it is a really tough call when you think about budget, because in a lot of communities you don't have the money for a lot of other things like good schools. And so how are you going to allocate the dollars? It's tough.
I will add that one of the things that the President's task force recommended was a greater federal role in funding some of the high-ticket technology. So if a local police department couldn't afford body cameras, for example, make federal grant money available for that. So that's one of the steps that the administration has taken enthusiastically.
I think we have time for 3 more questions. We had one here, and then back here, and then over here.
Hi, I was wondering if you could say anything about the role police unions are playing in this debate, how ready they are to embrace changes in policies and things like that.
I'll mention that. That varies depending upon which police department you're talking about. As an example with body cameras, one union, which I will not name, recently essentially blockaded the effort to get police officers to volunteer to wear the cameras. The head of the police there, the commissioner, had allocated some resources, got some cameras, wanted officers to volunteer to wear those cameras, and the union encouraged no one to volunteer. And so you didn't get anyone volunteering, and eventually you had some of the top brass who said, we're going to wear the cameras, and then officers essentially were just mandatorily assigned cameras. That is extremely problematic when you have a tool that is used effectively in some departments. Most police officers, when they understand what the cameras can do, they actually like the cameras because they realize this is essentially my alibi. This will prove that I haven't done anything wrong. And it also does get some people to calm down when they see the camera, if they're lucid enough, if they're not, under the influence of drugs. They see that camera and they realize their actions are going to be calculated. They're going to be captured on film. But so that is an example of where unions have done wrong. There's also been incidences like the blue flu, where officers are not supposed to go out on strike and things like that, just like in some other professions you're not supposed to strike. But unions can be good in terms of providing resources to officers who have been accused of misconduct cases. They need legal representation. Also, officers need to have decent working conditions, and they need to have fair hours that will not tax them and make them too tired to do their jobs properly. So there's good things about unions, and there's bad things about unions. I've been a union member, not for law enforcement, for something else, and I'm in favor of unions in terms of safety and advocating good conditions for employees, but when they interfere with doing the job properly, that's a problem.
I'll echo all that and just add one more point of complication. Sometimes department policies are the product of a negotiated agreement as part of a collective bargaining agreement with the union, and that makes it harder to change them, right? You can't just adjust policies that were the considered product of years, perhaps, of back and forth between the department and the uniformed officer. So that can slow the pace of change, and so that's another factor to consider. You're absolutely right. It's a workforce in which unions play an important role.
So I'm coming from a background in law enforcement, and I know this was a discussion that we had there, and so I'm just wondering, in your more of a legal opinion then, what are the barriers to having the, maybe state review boards for police officers like you see in other professions? I know like another pattern of a lot of these cases is that a lot of the officers did have, some sort of record or some sort of complaint filed against them at some point that, was never fully investigated, et cetera. But anyway, I'm just wondering what some of the barriers are to creating review boards for accountability.
Well, the FBI investigates allegations of misconduct. That's why you have the Department of Justice stepping in communities and FBI agents and other people from the Department of Justice coming in and looking at other law enforcement agencies. So that's one measure of accountability. There isn't any sort of uniform policy in terms of how use of force cases should be investigated. Part of it depends upon how many officers are in the area. I mean, if you have a little small sheriff's department, for instance, there aren't very many people there to work on the cases versus huge police departments. But that is, I think, one place where we could make some headway by having more of a discussion. Like I said, those hundreds of chiefs of police are trying to make some more uniform policies that will be used across the United States. And I think not just policies on how officers should behave, but also how you should investigate things after the fact, and then how you should communicate and train in the future.
One of the recommendations that both the Campaign Zero, Black Lives Matter makes and the President's Task Force make is for independent investigation and prosecution by some other board. In other words, don't have the prosecutors who work with these police officers day to day then have to make the decision, to depend on those officers to make their cases and have a close working relationship. Don't leave it to them to investigate use of force, have an independent prosecutor of some kind. The barriers to that are political. It's police departments do not like it, and they want to maintain some degree of control. They're worried, and not unreasonably, about a rush to judgment, about the sense that outside reviewers will be unfair to officers and won't understand the danger that they faced and will misunderstand the situation. So there's a kind of circle the wagons tendency with review of these cases. And so I think it's a political obstacle. But in principle, I think it's absolutely right that the working relationship is too close. It's enough of a whiff of a conflict of interest that I think it would be better to have some sort of central or either state review or another prosecutor's office handle it. But so far, those civilian review boards of one kind or another generally have limited powers. They don't investigate all cases, and hard to point to any of them as rousing successes yet. But the proposals in this direction have been advanced. FBI review, federal review, is available, but only for violations of civil rights, and that's a pretty narrow class, and the FBI's resources are quite limited. It's not an effective sort of review every use of force for its propriety kind of mechanism.
Hi, so the fourth factor in Graham versus O'Connor says that whether the force was applied in good faith effort to maintain and restore discipline or maliciously and sadistically for the purpose of causing harm. So what can be done beyond using technology in the event that the officer doesn't turn on the camera, we don't have audio, or someone isn't there to record it? What can be done to show the good faith effort or the malicious and sadistically for the purpose of causing harm? And if nothing can be done, should a new test be adopted?
Well, if you only have one individual on site and there's no camera, obviously it's just going to be the testimony of the individuals who were there. But I already talked about having better training at the academy, and then better training when you're on the job, better supervision and oversight in terms of by the training officer who's going around with that rookie crop and teaching the rookie cop how to behave towards the community, better management training about that, and so encouraging ethical policies and looking at cases also after the fact if something goes wrong, not just being transparent within the department but to the public, and using incidents where you do have an abuse of power as a teaching tool. But I don't think most officers are engaging, like what you're saying is, malicious types of misconduct. Sometimes the use of force may not be, proportional, but there's also a danger of using too low of a level of force to start out and then having the situation spin out of control, because what you want to do is de-escalate the situation as quickly as possible to safeguard not just the officers and bystanders, but the individual that's there on that scene.
So it's a good catch. it's unusual in Fourth Amendment law, actually, to have a test that turns on the subjective impressions of the officer. Did you act maliciously as opposed to in a good faith effort? In lots of other contexts, as my students in my criminal procedure class know, because we're studying it right now, we ignore these subjective intentions of the officer and we ask, was the action reasonable, which is to say objectively justified based on the circumstances. I could easily see a test that did not incorporate something like, did the officer act maliciously? What you would be left with, though, is then some sort of objective criterion for whether the use of force was reasonable, and that's things like proportionality. So I'm not sure jettisoning that malice would change the constitutional standard much. To the extent that we have to prove the defendant's or the officer's state of mind, it would be based on the circumstances surrounding the incident, and it would be unusual, I think, without a camera to have evidence that would support a finding of malice along those lines.
And when we consider, when we consider the actual reasonableness of the police officer, how do we incorporate the idea of implicit bias and the individuality of the police officers as individuals, considering that what may be a threat to one officer may not be, in theory, a threat to another officer? And they go further and say that actually implicit bias encourages a kind of threat or a kind of feeling, particular to certain races and minority groups.
So in terms of constitutional tests or self-defense tests, I've never seen any that incorporate implicit bias into the mix. That said, police departments are taking up implicit bias a lot more seriously today, and training is a lot more widespread about implicit bias. I hope it's working. It's definitely something that police departments are attuned to. It's just because it's implicit, it's by definition impossible to prove in the traditional way. And so a constitutional test that incorporates, I'm not sure what that would look like. And so I'm not quite sure how to, but it's certainly a highly relevant consideration when we're talking about police conduct, and therefore one that the good police departments are trying to tackle in a very direct way.
Okay. Thank you everyone for coming out.